Okay, Shannon, put us on the record, please.
Okay.
This is a matter of Baldwin versus Baldwin. Mr. Logera is here for the plaintiff, and both Tomasa Baldwin and Wesley Baldwin are also present. So I know we were scheduled for a pretrial, but we're on the record because there's also some objections to the temporary order.
Yes, Your Honor. We objected to the proposed temporary order regarding custody, parenting time, and child support. At the time I filed it, Your Honor, we were not objecting to the child support amount. We were just objecting to the onset date. But there's been a number of things that have happened since we filed this motion in February. Mr. Baldwin, the defendant's father, has not exercised any parenting time with the 3 minor children since I think the last time they spent any time together was February 21st, about 3 months ago. So if he's not going to be exercising his parenting time, we're going to need to recalculate the support. The objection at the time I filed it also dealt with Wednesday parenting time as not being in the 3 minor children's best interest. Then the last issue that I addressed, Your Honor, there was a check of $2,400 from the COVID relief from the government and another check of $5,600 that Mr. Baldwin kept all up. My client is confined to a wheelchair because of a surgery that she had. She could really use that money, is getting support inconsistently. We also have learned that Mr. Baldwin may have recently switched jobs and may have switched addresses. So there's a lot going on here. I do believe we have trial scheduled for next week, if I'm correct. The last time I had this motion up, the reason why I adjourned it is Mr. Baldwin wasn't present at that motion, and I learned that he was perhaps on orders with the Michigan National Guard, and I didn't want to run afoul of the Soldiers and Sailors Relief Act, and that's why we adjourned it, just out of an abundance of caution. Do you have any questions for me, Your Honor?
Well, I guess if we're scheduled for trial in a week, I can resolve all of these issues then.
That's what I thought too, Your Honor.
All right, well, let me just double check and see how my docket looks that day. Take me just a second to pull it up. You said next Thursday?
I thought so, Your Honor. I have it down for 1:30 next Thursday.
All right, hold on, let me pull that up. Gotta log in first. So I have 3 trials scheduled that day. Excuse me. One just went away. The other one, they've told me that it's very likely they're going to have the matter resolved. We kept the trial date on, so it looks like you've got a pretty solid trial date, so you can count on moving forward.
Thank you, Your Honor. That's always good to know. So I appreciate it.
How long do you anticipate?
Your Honor, I think we could get it done that day. There's not much in the way of property to argue about. I think the issues are pretty limited. I would, I don't want to make promises I can't keep, but I think we should be able to get it done that afternoon, I would hope.
All right, and have you had any conversations with Mr. Baldwin about narrowing the issues or
I have not.
resolution?
I have not, Your Honor. I have not.
Well, I would encourage you at least to reach out to him. Mr. Baldwin, we're scheduled for trial in a week, so we'll plan to see you here. Mr. Lujura, I might give you a call just to see if there's a possibility of narrowing some of the issues so that we can limit how long the trial is going to take, but you don't have to agree to anything. Ultimately, I'll be called upon to decide all of the issues in the case. I muted you, Mr. Baldwin, because I was getting a lot of background noise. Did you have any questions for the court?
Yeah. So, in regards to the parenting time thing, according to your court order, that's what's stopping me from doing it. I work Monday through Saturday. I work 4 to midnight, so Wednesday at 8 o'clock, I can't see my kids because I'm at work. The weekends, you said that I cannot see my kids on weekends that I work. I work every weekend. And I've been on military order since March 1st. And that's in the order that if I'm on military training, I can't see my kids. So as far as the whole objections to what he just said, everything that is in the court order is what's stopping me from even seeing the kids. That's the whole reason I haven't seen them, because I'm not going to go against your court order.
Mr. Baldwin, do you work 7 days a week?
I work Tuesday through Saturday. I have Sunday and Mondays off now. And that's it.
Normally, I would.
And that's a conflict because the kids are in school on Mondays, and that was one of her biggest concerns was the kids' schooling. So that would give me Sunday every week, 1 day.
Well, I can tell you, sir, that I one of the things I take into account in fashioning parenting time is the schedules of the parents. It's not the only thing I take into account, but that's certainly one of the things. If there's a way to coordinate parenting time in a way that matches with your schedule, I would certainly be receptive to that. That's perhaps something that
I just wanted to make it clear that that's the whole reason that I haven't seen the kids since February, because of what the court order shows, I was abiding by what that was in writing.
All right. So, Mr. Baldwin, I believe Mr. Lujura might be reaching out to you, and that's something that he's certainly willing to explore with you. It's definitely something I will take into account when we have our trial. One thing I'm going to have to ask you, this connection we have right now is very poor. This isn't going to work for trial.
It's because I'm on military orders.
I get.
We're back to Jackson right now from our military.
Okay.
Training.
All right,
So
and I get that. I get that.
The date or anything. I never received it
Right.
from the court.
All right. Well, as for today, this is fine, but I know it won't work for a trial to have such a sketchy connection. Where are you scheduled to be next Thursday afternoon when this case is scheduled for trial?
We'll be back in Michigan.
Oh, okay. So you'll be able to have a good internet connection then?
Yes, but I never received anything on the new date for the trial. I thought that was today.
No, today's the pre-trial. The trial is next Thursday at 1:30.
Okay. Is it going to be the same Zoom code and everything?
Yeah, same Zoom number. Yes.
Okay.
All right.
Mr. Baldwin, could I have a number where I can reach you at, a working number, please?
517 936 8439.
Okay, so I just want to read it back to you, 517-936-8439. When would be a good day to call you to discuss some of these issues, Mr. Baldwin? A good day and time? You tell me, and I'll make it work.
Whenever you want.
Okay, what about, how about tomorrow at 11 a.m.? Will that
Sure.
work for you? Okay, I'll look for my call then. Thank you, sir.
Okay.
Okay, thank you, everyone. I will see you next Thursday. Have a good day.
Thank you. Take care. Bye. Thank you, Your Honor.
Jeez, I would.
Okay, let me find this file.
Good morning.
Good morning again. Okay, we are on the record now and live streaming. Let's see, I gotta find your clients. Hold on. Well, they're not. Oh, here's Joseph's iPhone, so let me get him in, and I'm looking for Kelly, and there's Kelly.
Okay.
And as soon as we've got a good connection with everybody, we'll move forward. Well, we're having trouble joining Kelly. It says she's joining, but it's taking an unusually long time. Often when that happens, oh, here we go. Ms. Magsig, can you hear me?
There she is.
Can you hear me, ma'am?
Yes.
Oh, good. Okay, this is the matter of Magsig versus Magsig. Ms. Fleming represents the plaintiff, Mr. Fallahy, the defendant, and both parties are also present. My understanding is you wish to put proofs on the record this morning, Ms. Fleming?
Yes, I guess I would first inquire, Mick, did you see my email yet this morning after we spoke?
I did. Excuse me, I did, and I just sent you a response.
Oh, I'm sorry, I didn't see it.
That's
So-
okay. I just sent it a few minutes ago. I don't mind talking about it on the record if you're okay with it, but
Sure,
not exactly. So with regard to the savings account, and speaking with Joe, he's willing to do a $5,100, $2,000 split. So he'd receive $2,000. Your client would receive $5,100.
I guess I'm seeing my client shake her head.
We had a verbal agreement last night that I could have it.
So,
I'm willing to give you time in a breakout room if you need to discuss this some more.
Mick, is that the only issue?
I believe that it is, and I think we're in agreement on everything else.
As to the Acadia, what I proposed, that's acceptable? The refinance within 3 months, and if not, sell and equally split any deficiency or any proceeds?
You know what? Maybe we should go into a breakout room for a minute. I did forward that to Joe, but I don't know that we actually addressed it.
Okay. So, yeah, Judge, could you put us
I
in a
will do
room?
that. I will
Yes,
do
please.
that. When I see you back in here, I'll know that you're ready to proceed.
Okay.
Thanks, Judge.
Okay, folks, just follow the instruction on your screen.
Thank you.
Okay, I do have the matter of Metcalf versus Metcalf. I see Amanda Metcalf is present. Good morning, Ms. Metcalf. Can you hear me okay?
Yes, I can. Good morning.
Good morning. This is the matter of Metcalf versus Metcalf. We're scheduled for a pretrial today. What I do at a pretrial is determine whether or not there's going to be a need for a trial, and if so, what are the issues that are in dispute. I do see that Mr. Metcalf, who's not present, oh, I'm sorry. There's an attorney on this file. I didn't realize that. Let me bring in Mr. Campbell. Good morning, Mr. Campbell. This is a matter of Metcalf versus Metcalf. Mr. Metcalf is not present. You haven't received notice of an appearance from anyone on his behalf, have you?
No, I haven't, Your Honor. Good morning, by the way.
Good morning. So,
there was a default entered early January, Your Honor. He hasn't really participated other than in front of the court. The parties have been separated for some time. They really have no assets. And I would just ask if we could do the pro-con today, and then I'll submit a judgment to your office.
I can certainly take pro-con proofs. However, I cannot enter a default judgment of divorce until you've served well, let me back up for a minute. What's your current trial date?
I believe it's, sorry about that.
I can look it up. I mean, normally they write it in the jacket, and for some reason they didn't on this one.
I believe it's June 3rd. That's a Thursday. It's 2 weeks from today.
So if you want, just show up at the trial, have a proposed judgment. If he doesn't show up and it's the scheduled trial date, he doesn't get advance notice of entry of default judgment as the court rule requires. I think it requires you to serve it 14 days ahead of time. If we're here on a motion for entry of a default judgment, you got to follow the court rule. If you're here for a trial and he just fails to show up, I'll take whatever proofs are necessary then, it won't necessarily be a default judgment. It'll be a judgment ordered by the court. Just have one prepared. You don't really have time to get in any sooner than that anyway,
Okay.
unless you were to send out today a motion for entry of default judgment and a proposed default judgment of divorce. Let me just look at the rule again real quick. Yeah, it says if default is entered for failure to appear for a scheduled trial or hearing, notice under this sub-rule is not required.
Okay.
So let's just plan on doing that. And I have to have a proposed judgment in front of me before I can even take proofs. So let's just keep you on for the date you've got for trial. I'm assuming if he hasn't shown up today and hasn't shown up before, he's probably not going to show up again. It'll be pretty simple for me to take some basic proofs and enter judgment.
Okay. Fair enough, Your Honor. Thank you.
All right. Well, thank you. Have a good day.
All right. Take care. Bye.
Okay. Metcalf. Magsig, looks like they're still talking. And it looks like Lemay. Let me see who's here on this. Bailey and White. I see Eric White and I see Patrick Bailey. It's okay. Let me get them in. All right, we're still waiting on Ms. Fleming. I'm going to move to another matter. Okay, this is a matter of Lemay versus Lemay. I see Mr. White is here for the defendant, and Mr. Bailey is here for the plaintiff. And Mr. Bailey's present. I don't see Ms. Lemay. Were you expecting her this morning, Mr. White?
Yes. I was sure she was going to log on. We went over the instructions yesterday afternoon.
Boy, unless sometimes people log in on other folks' devices without changing the name.
And if you could pass me, I guess, Judge, I'll just wait and see, and I'll try to get in touch with her maybe by email.
All right, we'll put you back in the waiting room then.
Thanks.
Okay, we're back on in Magsig. Are we prepared to enter with Tanner proofs this morning?
Yes, and a settlement, Judge.
Oh, good. Do you want to do the settlement first or the proofs first? What's your pleasure?
Why don't I go ahead and read the terms of the settlement, and then I can inquire of my client.
Very good.
Thank you. I am, for everyone's reference, I am referring to my letter to Mr. Fallahy dated April 23rd, 2021, with some minor revisions. Custody, the parties will continue to share joint legal and joint physical custody of their two minor sons. Parenting time will continue as outlined in the temporary orders. Child support will continue in the amount pursuant to the temporary orders. Once the divorce judgment is entered, the divorce case, and there is an older support case, they will be consolidated, and all future support will be charged under this divorce file number 2020-3653DM. Beginning with the tax year 2020, each party will claim one child for tax purposes. The plaintiff mother will claim Finley and the defendant father will claim Landon. When only one child may be claimed for tax purposes, the parties will alternate claiming that child. However, a party will not be entitled to claim the child for any year in which there is a child support arrearage of more than 30 days duration with respect to such child as of the last day of that year. The parties will file separate returns for 2020. As to life insurance, Mr. Magsig will carry and maintain life insurance on his own life and name the plaintiff as a beneficiary under the terms of that policy as security for his obligation for child support. He will furnish her with proof of his compliance and maintain such policy in full force and effect as long as his child support obligation continues. Professional health care insurance, the defendant father will continue to provide the insurance for the minor children as available through his employment at no reasonable cost. The plaintiff mother will be responsible for ordinary professional health care expenses. All extraordinary health care expenses will be paid 31% by the plaintiff and 69% by the defendant. Neither party is entitled to alimony or spousal support, and the same is forever barred. Personal property, the plaintiff will receive all financial accounts in her name. The 2015 GMC Acadia vehicle and all personal property in her possession. Mr. Magsig will receive the joint account at Independent Bank, the 2011 Kia Optima, and all property in his possession. The plaintiff will keep the savings account. She will sign the title to the Optima to Mr. Magsig within 14 days of entry of the judgment of divorce. Each party will retain one of the chairs made by Angie. The plaintiff will retain the Wood, Michigan sign, and Mr. Magsig will keep all other property listed by him in his verified financial information form. There is no joint debt. The plaintiff will refinance the debt to GM Financial on the Acadia vehicle within 6 months of entry of the judgment. If she is not able to finance that loan in her name, the vehicle will be sold and she will be responsible for any deficiency, or she will keep any proceeds. Mr. Fallahy, I know I did a pivot on the number of months, but if she's going to be responsible, we went back to the 6 months, but she's confident she'll be able to do that. The plaintiff has no retirement benefits. The defendant has an interest in the Trinity Health 403 retirement savings plan. The plaintiff is awarded 50% of the value of that via a quadro. I'll prepare the quadro and she'll receive 50% as of the date of entry of the judgment of divorce. Mr. Magsig has a business entity, Elite Drone Services LLC. He'll receive that as his sole and separate property, and he will indemnify and hold harmless the plaintiff from any liability in respect to that business. I believe that contains all of the provisions of our settlement.
Mr. Fallahy, can you confirm?
Judge, yeah, if I may, real quick, Ms. Fleming, I don't know that I heard you say that your client would begin making the payments on the Acadia starting June 1st, but that might have been during the time I was looking at your email you sent me regarding the time frame. So
you are correct. She will make payments beginning June 1, 2021.
And
I didn't have it written down. Now I do.
No problem. And we didn't really talk about this, but I'm assuming that there's a requirement to keep it insured. So it'll remain insured as well while she's driving that. So just because my client's name is going to remain on it, I don't want there to be any liability issues in terms of.
Sure. She'll have to keep it insured.
Okay, thank you. And then, Joe, I know you're muted right now, but you, can you hear me okay?
Yeah.
As Ms. Fleming indicated, there was a little pivot on the time frame there. Are you good with 6 months to refinance the vehicle?
Yeah, that's fine.
Okay, all right. Thank you. Then, Judge, I guess with that confirmation from my client, I think that the rest of the settlement is agreeable.
Okay, Ms. Magsig, would you raise your right hand, please? Uh-oh, she's frozen.
Uh-oh, there she goes.
There we go. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down now. Please state your full name.
Kelly Lynn Magsig.
Go ahead, Ms. Fleming.
Thank you, Your Honor. Kelly, you recall last fall you signed a complaint for divorce in this matter, is that correct?
Correct.
And were the statements contained in that complaint true on the day you signed it?
Yes.
Specifically, had you been a resident of the County of Jackson for at least 10 days and of the state of Michigan for at least 180 days when you signed the complaint?
Yes.
There are 2 minor children that were born or adopted during your relationship with Mr. Magsig. Is that correct?
Correct.
Are you pregnant today, to the best of your knowledge?
No.
Has there been a breakdown?
No.
You're not pregnant. There's a little delay.
She did say she was not pregnant.
Okay. Kelly, has there been a breakdown in your marriage relationship? Has there been a breakdown in the marriage?
Yes.
Is there any reasonable likelihood that your marriage can be preserved?
No.
You have heard the terms that I just recited into the record. Is that correct?
Correct.
Okay. And you understand that the terms relating to the custody, parenting time, and child support for your children may only be modified upon a showing of a change in circumstances. Do you understand that?
Yes.
And you understand that the property settlement provisions, once the judgment is entered, they become final. They cannot be changed, only enforced. Do you understand that? I'm sorry, I didn't hear your answer.
Yes.
Okay. And knowing that, once I have reduced to writing the terms into a final judgment of divorce, do you wish the court to enter that judgment, and do you wish to be bound by those terms?
Yes.
Rather than going forward with the trial in 2 weeks, you would rather the judge accept the settlement?
Yes.
Do you have any questions of me or of the court?
No.
Thank you, Your Honor.
Mr. Fallahy, do you wish to question your client regarding the terms of the settlement?
Yes, please, Your Honor.
Go ahead.
Thank you. Joe, can you hear me okay?
Yeah.
You've had an opportunity to hear the settlement agreement that we've placed on the record today. Is that correct?
Yes.
You understand it?
Yes.
Do you feel that it's fair under the circumstances?
Yes.
And you realize that at this point, we have a trial scheduled, I believe, 2 weeks from today. And at that trial, you could do better, you could do worse, or you could do about the same. But you're waiving your right to a trial on these issues if you enter into this settlement agreement today. You understand that?
Yes.
And upon presentation of the written judgment and other related documents, you would ask then, after we approve those, that the court sign and enter those documents as the final orders in your case. Is that correct?
Yes, that's correct.
Okay, and do you have any further questions for me or for the court today?
No.
Thanks, Joe. I have no further questions, Judge.
Very well. I am satisfied based on the proofs that there has been a breakdown in this marriage to the extent the objects of matrimony have been destroyed. There remains no reasonable likelihood, excuse me, that the marriage can be preserved. I will sign the consent judgment of divorce upon presentment. We'll keep your trial date on simply as a status conference to make sure that the judgment is in.
Thank you, Judge.
Thank you all.
I'll get that prepared and get it over to Mick early next week.
Thank you.
Thank you. Have a good day,
Kelly, and I'll
everyone.
send it to you.
Thanks, Judge.
Thanks. Have a good day.
Your Honor, I'm going to stay on. I have one more hearing with you unless you want me to be kicked off here.
You could stay. I can always kick you into the waiting room.
I can
I
mute
don't care.
myself.
You can-
Judge.
That's fine.
Judge, it's Susan. I just walked off without the Barnett file. The courtroom's locked back up.
Oh, sorry. Well,
Thanks.
I saw you logged in, and I saw Amy Lammers was logged in. So I was wondering what was going on. I'm going to let her know that we're done with her case.
We've told her, so I don't know why she's still logged in.
All right. Maybe
Okay.
I'll just remove her then.
Okay, and if John will let me in, that'd be great. Thank you.
John, let her in. Would you unlock the door, please?
I thought I did, I guess.
You know, sometimes if you bump the little button, it'll stay locked. So, sorry about that, Susan.
Thank you. It's my fault.
Magsig. Lemay. I think it's up here, Susan.
Hey, Suze. Hello. Have a good weekend.
You too. That's pretty bad when you got to zoom in to be let in the courtroom door.
That's why they shouldn't let attorneys roam around the courthouse yet.
I thought I saw someone's head out there through the little double windows, but I didn't think much more of it. I was more focused on my courtroom, as I should be. Okay, I think we've got everyone here on the Lemay versus Lemay matter. Mr. Bailey for the plaintiff, Mr. White for the defendant, and both parties are present. And we're here on objections to the ex parte order that was entered regarding the minor children's school. So, since it was issued ex parte, I think the burden is on the plaintiff to convince this court that that order should remain in effect. So let me hear from you, Mr. Bailey. I'm sorry, Mr. White.
Your Honor, if I may, as the court's aware, we're towards the end of May and the school year is going to end very shortly for these children. They're back in school where they were. We have no intention of asking the court to remove them and put them back where Ms. Lemay had them. But we felt it was very important to file an objection and to get an answer in the court file to protect the record that you saw from our answer. If you look at the petition or the ex parte motion that was filed, you would think this is just some kind of run-of-the-mill case. And you can see from our answer that there's a whole lot going on here. It was important that that be part of the record, and that while we certainly object to that ex parte order, we were simply protecting the record to deal with all of the allegations in that motion that were untrue. So I'm not sure how the court wishes to proceed. We're not going to pull kids out of school at this late juncture. It'll just be an issue for this trial this summer when we just try to decide where they go in the fall.
And let me be really clear. Unilateral changes in schooling, I don't look kindly upon. I realize you're separating, you're not a couple anymore, but changing kids' school without communicating and without agreement is something that I frown on. I recognize sometimes circumstances require when one parent is being particularly obstreperous. I'm not suggesting that's the case here, but in the normal course, I don't want these kids' school changed between now and the end of the year. I hope that's clear.
It is, Your Honor. I had that conversation with my client, and we're fortunate. We're at the end of the school year. We can address this in due course.
Okay, so you're also here on a motion to enter a PPO, correct?
That is correct, Your Honor.
Mr. Bailey, was there anything you wanted to say about the objection to the ex parte order?
Yes, just for the record, Mr. Lemay stands by everything that was put in the motion for ex parte. The last day of school is June 17th, and the parties have a fixed C on June 1st, and we figured that the matter of school district and custody would be handled during the summer before the kids resumed school in the fall.
Okay. If the parties are unable to work that out, we'll try to get you a hearing date in sufficient time for that to get resolved. So I'm looking for that other file. Hold on a minute.
Unfortunately, the pretrial and trial date's not till after school starts, so we'll probably have to address that probably sooner than later this summer, I guess.
Yeah, and I agree, sooner rather than later. If you're unable to work it out, just get a hold of Dawn to get a date. I will certainly hear that issue before school starts.
Great, thank you.
Oh, it's right here in front of me. Okay, the next matter is the PPO matter, file 21-1365. This is the petitioner's motion for entry of a personal protection order. I'm assuming, Mr. Bailey, your client opposes this.
That is correct.
All right, so we'll start with any introductory remarks, Mr. White, or should I just swear your client?
Swear my client, Your Honor. Thank you.
Ms. Lemay, you need to unmute.
Deb, you gotta hit the unmute button. It's probably lower left.
Oh, okay. Ms. Lemay, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I didn't hear a thing. Check your audio settings. You might have to turn your microphone volume up. It's in the lower right-hand corner of your screen where the audio, there's a little arrow there that you can click on and it'll allow you to adjust the volume. That's where it should be anyway. All right, you just muted again. It's in the same vicinity as that mute button, but there's also a way to adjust the volume of your microphone, and you need to do that.
The little arrow next to the mute button, at least on mine. And you just
all right, let's do this. Mr. White, do you have her phone number?
I do.
I'll just call her and we can keep the visual image going and we can hear her by phone.
Okay. Ready?
Oh, actually, I see it's on the petition. I'll just dial that number. Ends in 5230.
That's what I have, Your Honor, yes.
Okay.
Good morning, Your Honor. Good morning, Your Honor.
Good morning. So we need to mute because your speaker is working.
Hold on one second. Okay, is that better?
Okay, that works. All right, ma'am,
Okay.
would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down now. State your full name for the record.
Deborah Ann Lemay.
Go ahead, Mr. White.
Thank you. Ms. Lemay, do you remember filing the application for a personal protection order in this matter?
I do.
Okay. Was this the first time that you had sought a PPO against Mr. Lemay?
No, it was not. Originally, I filed for divorce September 16th of 2019. And was awarded a PPO then. We reconciled and tried to work on things, and I don't believe there was ever any participation on his behalf. So I filed a PPO in March, and I was going to set up the
Hold on.
for a hearing, but then I had new information and put in a new PPO that we're discussing today.
Can you tell the court about the incident roughly on April 20th, 2021 that you describe in your PPO application? What happened?
I can, and I did want to interject at the schooling, but this sort of talks about it too. We've been married for 20.
Deb, hold on. You just got to answer the question that gets asked. I know there are things you want to say, but you just can't talk. You have to wait for the question that you get, and that you have to answer that question directly, okay?
Yep.
Okay, so tell the court about what happened on April 20th, 21 that gave you concern to try to get a PPO.
Early in the morning, Daniel called me and told me to pick the kids up from school. He had things to do. He then hung up, was unavailable to be reached by phone over the course of the next 7 hours. And I arranged for alternative pickup as I was at my mother's preparing for my knee surgery and my knee replacement. And after he called me irate about having somebody pick the kids up, he told me his appointment was 3 o'clock and it was already 3:40 when the kids were brought home by a third party. And he went ballistic that I would not return home. Absolutely crazy. I then get a phone call from our pastor, who I also...
Let me stop you there. Was when he contacted you and was irate, was this by telephone or was this in person?
By telephone.
Where were you at when you took the call?
At my mother's.
Do you know where he was calling from?
In Pinckney, Michigan.
I'm sorry, you cut out.
I was at my mother's house in Pinckney, Michigan.
Where was he calling from, if you know?
From the home in Brooklyn.
Okay.
My children were there.
Okay. Again, just got to answer the questions, okay? You described him as irate. What exact statements, or could you describe his demeanor on the phone that would make you describe it that way?
Oh, he was cursing, using 4-letter F-bombs, wishing me dead. I can't even do this.
Let me stop you there. Let me stop you there. Wishing you dead. What exactly did he say on the phone on that date about wishing you dead?
I wish you would just die, bitch.
Has he ever made statements like that to you before?
The first time that I got a PPO, yes. When I was truly in fear that he was going to snap, yes.
How did that make you feel when he made that statement about wanting you to die?
I mean, it made me feel isolated, alone, like I don't have a partner in life, like I've been, turned upon. I felt like, what do I have? And I was scared. I mean, my kids were with him and he's, wishing me dead.
So you're scared. What else did he say that gave you concern?
You'll return home now, or you'll pay.
Did he say how you would pay?
No.
Did he make any other threats to you at all?
Not that I can recall at this time, but there are extenuating circumstances that I later found out in a phone call.
But at that time, those were the only threats that he made?
Yes.
So after he made these statements, what did you do then?
I then took the phone call from Daniel White and called for a police escort, a police standby, and got a driver and headed out to the house in Brooklyn.
Hold on. You called a pastor? Who did you call?
The pastor called me out of concern.
Okay. What's the pastor's name?
The pastor told me
Objection.
that,
What? No.
quote
Not what the
unquote,
Hold on. I think she misunderstood the question. Say it again, Mr. White.
What's the pastor's name?
Daniel White,
And what church is he affiliated with?
Fellowship Baptist Church, where the kids also go to school.
And do you and Mr. Lemay attend church there as well?
Yes.
You can't say what the pastor said, but you received a call from Pastor White during this incident or during this general time frame?
Yes, I did.
Based on what Pastor White told you, how did you feel about the situation?
I was terrified for my children's safety as well as my own.
Based on the statements that Pastor White told you?
Yes. He's been our pastor for 5 years and never initiated a phone call to me.
This is the first time Pastor White ever called you?
No, but usually it would be a return phone call. He was acting as a go-between in his own words. I have that and can show you. Not as a counselor, not in confidence. He was acting as a go-between since the first filing of the divorce.
Okay. Based on what Pastor White told you in the statements, you arranged for a police escort? Did I hear you correctly?
Yes.
Why?
Well, I was told that Dan was going to take a match to the house while the children.
Deb, stop. Again, remember, you can't say what the pastor told you, right?
Okay, so what was the question? I'm sorry.
You felt, I was just confirming that you actually got a police escort back to the home in Brooklyn. Is that correct?
Yes.
And
I had my sister pick me up and drive me out there as I was still afraid to be alone at any time with him.
What happened when you arrived back at the home?
The police had actually, I had to call 911 again. The police had actually gone and talked to Dan and left. And I called them back, and the police officer told me that the kids had to willingly come with me, that nobody could have physical hands on the kids to stay or to go. And they all willingly came with me.
Did you have any interaction with Mr. Lemay?
Yes, I did. At that particular time, Danny ran up the stairs to get the keyboard part of his computer that separates from the screen. Dan was up behind him. The police officer was still at the sliding door because Danny ran to get it out of excitement. And Dan actually pushed me down one step, knowing that I had just had my right knee replaced and I was going in 2 days to have my left knee replaced.
Did anybody witness him assault you like that?
No, the officer came around right after that had happened, up the stairs.
What about the kids?
No, he was in front of Dan.
How did that make you feel?
Very vulnerable and scared because there was a police there to make sure this didn't happen. And Dan is very calculating, manipulative, and takes every opportunity he gets to, set me back.
Based on the previous issuance of a PPO and the incident you're describing on 4/20, how do you feel things are going to go forward with this pending divorce?
I'm sorry, how do I feel what?
How's it going to, is this going to go smoothly, or do you have some concerns about your safety still?
Oh, no, I have huge concerns. The kids left with the clothes on their back, as did I. And I went back out to get clothing, which I got their clothing in a basket, and he's so calculated that he pushed the basket when I was on the porch. Careful not to push me, but knowing that I had no balance, I was still on a walker or cane at that time while I'm trying to retrieve clothes for the kids. And he pushed the basket. And I also had a third party standby at that time. So the fact that he's losing it in front of third parties at this point really concerns me, because I feel like he just doesn't care at all anymore. And he's willing to do whatever he can to hurt me.
You'd like the court to issue a personal protection order against Mr. Lemay, is that correct?
Yes, I would.
So, you know, we're going to the friend of the court in about a week or so for temporary custody and things. If the court were to give a personal protection order, how would you and Mr. Lemay continue to co-parent these kids and be able to communicate for their best interests?
Well, it's going to have to be through a third party. I have tried to talk with him regarding co-parenting, and every conversation turns into what I've done to him and how I am just a no good piece of shit, and he hangs up on me.
Has that happened recently?
At least 6 times within the past 3 or 4 days. Oh, and one other thing to mention, in the PPO, I had requested, that he couldn't get near the animals. I had somebody feeding the horses. He pulled out the hose, ran over all of the connections that were plastic. We had to give the guy more money to go buy a hose. He also put tires or nails in the driveway, and he had to fix 3 tires. And then he called and left a voicemail on my answering machine, which I currently still have, telling me that the horses are out loose. All of this just to get me to come back home.
Are you interested in coming back home, Ms. Lemay?
Not with him there.
What are you doing right now?
I would be too afraid.
What are you doing right now for a roof over your head?
I go between my mother, but she has severe headaches, so I can't stay here when the kids are here. So I go to my sisters with the kids, and when they're visiting their dad, I come to my mother's. But I need to, sorry.
Oh, go ahead.
I need to get into counseling myself, and I need a somewhat permanent address to do that. I had also requested that you sent a letter 18 days ago, and he answered a 3-page ex parte order, but didn't agree to counseling for my son, because when he talked to the school counselor, CPS got involved.
Yeah, we'll talk about that. Did you say CPS is involved?
Yes. He was talking to a counselor and telling people on the bus that is, I'm sorry, go ahead.
How and why did CPS get involved in your case?
Apparently he divulged something to the counselor that told the principal, and the principal of the Dexter school.
Let me stop you there. Deb, hold on. You said he. Who's he?
Danny, our 8-year-old son.
Okay. So he did
said
what?
Something in counseling that.
Well, I guess I'm a little confused. Is Danny in counseling?
No, because we left Dexter schools per order and sent him back to Fellowship Baptist. They don't have counselors available. I immediately.
Deb, stop.
Okay.
You just said that Danny divulged something to a counselor that got CPS involved. And then you just said he doesn't have a counselor. Which one is it?
Well, he had a counselor when he was at the Dexter schools.
Okay. And he made a disclosure to the Dexter counselor that CPS became involved?
The counselor notified the principal, and the principal called CPS to report.
Okay. Have you been contacted to give a statement regarding that?
Yes.
And you provided all the information to CPS. Did they interview the children? Do you know?
Yes, I believe they did. I even gave the officer a key to my house that I still have to retrieve.
Have you been notified by Child Protective Services as to the status or disposition of that investigation?
Yeah, they said that law enforcement took lead because this was turned over to the prosecuting attorney for a felonious assault, and I have not heard any progress or withdraw from that.
So the answer is it's not been resolved yet. Is that correct?
Correct.
And there is a
not to my knowledge.
And there's been a police report submitted to the Jackson County Prosecutor's Office seeking felonious assault charges against your husband?
To my knowledge, yes, by the Columbia Township Police.
Who did he feloniously assault?
Our son, Daniel, 8 years old.
Okay. That's all I have, Your Honor, for now.
Questions for the witness, Mr. Bailey?
Thank you, Your Honor. Ms. Lemay, can you hear me okay?
I can.
Who are the children with right now?
I'm sorry?
Who are the minor children with right now?
Currently, they're on visitation with their dad and in school because I have no legal jurisdiction.
Okay. But didn't you say you were fearful for your children's safety, but yet they're with Mr. Lemay right now voluntarily?
It's not voluntarily. I have no legal recourse. He told me if I don't agree, he will just go pick the kids up from school. Again, the pastor called me and told me he could not protect them without an order.
Ms. Lemay, can you please just answer the questions that are asked?
Yep.
Okay. Have you done any parenting time exchanges with Mr. Lemay?
Yes, we have done one that I pulled up in the driveway with a third party and the kids came out. And then we did another exchange at Baker Road in which, Chelsea, in which Dan says that I walked approximately 100 yards. I have a statement notarized right here that did not happen. I did not walk more than 12 yards there and back. It was pouring rain, and the entire park and ride is probably not even 100 yards.
Okay. Again, please just answer the questions that are asked. Did you voluntarily walk up to Mr. Lemay, exchange documents and some cash for some bills?
No, he was in his car when we exchanged the bills.
Did you voluntarily walk up to his car?
Yes,
okay.
Not alone.
Again, just answer the question asked. This will go a lot easier. Thank you. Since filing that petition for a personal protection order, did you and Mr. Lemay talk almost daily about the children?
Several conversations hanging up, all by Dan, mad at me, because he cannot stay on topic about the children, rather argues about us.
Ms. Lemay, it was a yes or no question. Have you talked several times on the phone about
No.
You haven't called him?
I would have to say no. I would have to say no then.
Okay,
he does not stay on topic.
Have you called him over 15 times since April 21st?
I don't know. I would say probably close.
Okay. Now back to April 20th, April 21st. When Mr. Lemay called you to ask you to come home to watch the children, how long had you been vacant from the residence?
24 hours.
Okay. And was this the first time that you had left the home for a knee surgery?
No, I left during my other knee surgery as not to burden him.
Okay. When was that knee surgery?
That was March 15th.
Okay. Were you gone for approximately 20 to 25 days during that time?
No, I came home 8 days after a total knee replacement.
Okay. And how many days were you gone before the total knee replacement?
I think 5.
Okay. So you were gone at
I would
least,
have to double check. I think 5.
okay, but you were gone at least 13 days?
Probably so,
Okay. And you left the 3
as
minor
a guesstimate.
and you left the 3 minor children with Mr. Lemay?
It's not a choice.
It's a
I
yes
don't-
or no question.
A PPO doesn't.
This is Lemay. You have to answer the questions. Confine your answers to the questions asked. Don't go beyond. Don't volunteer information. Ask your question.
Yes, Your Honor.
Ask your question again, Mr. Bailey.
Okay. You left the minor children home with Mr. Lemay during that at least 13-day period?
Yes.
Okay. You stated on the record that in that phone call around approximately April 20th, Mr. Lemay said, quote unquote, "I hope you die, bitch." Is that correct?
Correct.
Why did you not put that in your petition for personal protection order?
It was in the one for March. This is a frequent statement that he says. However,
But we're not here for
when
that.
he loses it like he has, I'm much more concerned.
Okay. You also said, or you also testified that Mr. Lemay said, "You will return now or you will pay." Why did you not put that in your petition for personal protection order?
I'm under an exuberant amount of stress. I'm on the road. I don't really have a place to call home. I have 4 articles of clothing, and I have 2 knee replacements over the course of 5 weeks. It does take time to reflect on everything.
Okay. You also testified that Mr. Lemay pushed you down the stairs while the police were present. Is that correct?
I testified that he pushed me down 1 stair.
Okay.
Yes.
Okay. Why did you not put that in your petition for personal protection order?
I thought I did.
Okay. If the police were present, did the police witness you hip check Mr. Lemay and tell you to cut it out?
I think so.
Okay. You mentioned several times that there were third-party witnesses.
Oh, excuse me. I must say, yes, that did happen, but it was when I bent over to give my son my shoes. Yes.
All right. Ms. Lemay, you testified that there were third-party witnesses to a lot of these altercations with Mr. Lemay. Is that correct?
That's correct.
Okay. Where are the witnesses for today's hearing?
I don't have them here today as I didn't know that I need them. I have 11 people, including 2 Michigan State officers and a state detective with body cams that are willing to testify. I have a total of 11, 3 being law enforcement and 8 being personal friends of the family.
Okay. If this was your,
I did not know that I would need that for today.
if this was your hearing for a personal protection order, when else would you have needed those witnesses?
I thought during the, I sent my lawyer a letter last night with those names, and I thought that I would need them through the course, family of the court and the custody issues, not so much the PPO. Like what happened was real. I didn't think that I would need their names because some of them are not relevant to the PPO.
Okay, so you thought your testimony alone today was good enough?
I did. And the one thing I didn't think was going to be good enough, I did print out the statement that I was texted from the pastor that does indicate he was not serving as a confidant, that he was acting as a go-between because he's key to this case. And I do have this paper that I printed off from my screen.
Okay, Ms. Lemay, please just answer the questions that are asked.
I'm trying to, but I want to be complete.
That's not your job. Your job is just to answer the questions. Ms. Lemay, how far away are you, or how far away is your mother's house from Mr. Lemay's and yours marital residence?
It is about an hour.
Okay. And are you currently in fear for your personal safety?
Yeah. And every time I have to get near him. And I had the horses picked up and relocated because I don't know what he's capable of.
Ms. Lemay, that's not responsive to the question. Try to contain yourself.
I apologize.
Ms. Lemay.
Yes.
If you're currently in fear of your personal safety, why have you gone to 2 parenting time exchanges and let the kids be with Mr. Lemay?
Because the law does not provide me an option. They're legally his children, and until we have a determination otherwise, he's able to see his children. Even if granted the PPO, he's still able to see his children.
Okay. So one last question. You stated that the police department is investigating a felony assault against Danny, your minor child, but yet you've given Danny over to Mr. Lemay. Is that in accordance with the law?
As I'm told, until a decision has been reached by the prosecuting attorney, yes.
Okay. And has Mr. Lemay been charged or arrested for anything?
I have no idea.
Okay. I have no further questions.
You redirect, Mr. White. You're muted, Eric.
Sorry, Judge. No, thank you.
All right. Any further witnesses, Mr. White?
No, Your Honor, thank you.
Okay. Mr. Bailey, I'm assuming you want to present your client's testimony now?
No, I don't have any witnesses.
All right, fair enough. I guess I'm ready for arguments then. Mr. White?
Thank you, Your Honor. Given that Mr. Lemay's decided not to testify, the court's pretty much obligated to take the uncontroverted testimony of my client at face value and issue the PPO. Thank you.
Mr. Bailey?
Yes, thank you, Your Honor. The burden here is on Miss Lemay to show that she's in fear of her personal safety or her children's personal safety. Her testimony on cross-examination would show that a lot of what she said was not, in fact, true. She has no witnesses to back up her statements. She's presented no exhibits today. She's over an hour away, and she's voluntarily seen Mr. Lemay since filing the petition, as well as had several conversations with him. So it's our argument that the personal protection order is not warranted, that she's not in fear of anything right now, and that the parties are a good distance away, and during these divorce proceedings, they'll stay a good distance away from each other. Thank you.
All right, thank you. Whether or not she is in fear, she testified she is. I have no reason to doubt that. But there's still a question of whether or not the fear is reasonable. I haven't heard sufficient evidence to convince me that a PPO is necessary in this case, so I'm going to deny the request.
Thank you, Your Honor. Mr. Bailey, are you going to be on this case, or is it going to be Amy?
I was covering for Amy's
okay.
Ex parte matter, the personal protection order. My appearance was on record. Amy and I will probably work side by side, but you could send correspondence to either one of us and the issues will be handled.
Cool. I just wasn't sure where to send it to. Appreciate it.
That's fine. Yep.
Ms. Lemay, we'll talk here this afternoon. Thank you, Your Honor. Appreciate your patience today.
Have a good day.
Thank you, Your Honor.
There's a blank PPO, but there's no order.
Okay. I'll just do one right now.
Mr. Falahy, what was the other matter you were here on?
Judge, I'm here on the PPO case of, I'm representing Kimberly Rowley, and the the petitioner is the Ashley Keller.
All right, I'll write that down. I've got someone else ahead of you here, so they've been waiting a long time, so we'll get you back in here shortly.
Okay, thanks, Judge.
Mr. Lyons, can you hear me?
That's odd.
Oh, it is. Well, he's still there. They must have, yeah, everyone else disappeared. So I saw those names here. We just put them back in the way. He must have forgot to log off. Okay.
Just here's the order for you. Thank you.
Oh, Shannon,
Did I do it on the wrong one?
no, you typed over her address on the second line, so it's not visible.
I didn't. It's just,
Oh, it's just showing up that way on the printer.
it's just,
Well,
I didn't.
it doesn't necessarily have to be on it as long as it goes to her
Yeah, it didn't.
or goes to her attorney. She's actually not pro per on this either, because Mr. White represented her. I guess we probably
If he
should.
didn't file a appearance, then then
Yeah.
they don't have anything, then they didn't put anything in the docket, and he didn't file an appearance for the PPO.
Okay, so let's see. I'm gonna take just a short break. I gotta take a pause.
Riley's off. If you want to grab
Which one's off?
Riley.
I must have gotten tired of waiting. Mr. Lester, can you hear me?
Yeah, yes, I can.
I don't see anyone logged in under the name Juan Johnson. I do have an iPhone. Let me see who that is. I don't think this is right, but let me at least find out who it is. I just let an iPhone in. Could you tell me what your name is, please?
Cassandra Holmes.
All right, I'm going to put a name on the screen so I know who you are. And let's see, you are you are here on the matter of Holmes versus Trudell, correct?
Correct.
All right, well, hold on a second. I'm going to put you back in the waiting room. I'll bring you back in as soon as I'm ready to call your case.
Okay, thank you.
All right. I've got someone logged in. It's on Cody's device. I'm going to see who that is. Sometimes people borrow phones or laptops and they don't change the name on it. So I want to see who this is.
Okay.
And we got to wait to make an audio connection. Sir, if you can hear me with the beard, what is your name?
My name is Cody Trudell.
Okay, Mr. Trudell, I'm going to put your name with this device so I know who you are. I'm going to put you back in the waiting room for just a minute. We'll bring you back in when it's time.
Okay, sounds good.
Okay, I am not seeing Mr. Johnson logged in under anything else. All the other people are identified. Looks like this matter was scheduled for two things today. One is a motion by you, I believe, to set aside a PPO. Is that correct?
Yeah. Yes, Your Honor.
But this is your PPO. Well, hold on a minute. No, I'm sorry. It's Mr. Johnson's PPO against you. You filed a motion to set it aside. Mr. Johnson's not here. It's his burden to show that a PPO should remain in effect. I am going to grant your motion. I'm going to dismiss the personal protection order, and I'm also going to dismiss the show cause that was scheduled. There is an order here.
I didn't hear you, Judge.
I'm going to grant your request, sir, to terminate the PPO and to dismiss the show cause because Mr. Johnson failed to appear.
Okay.
Which is what you wanted me to do, correct?
Absolutely.
Okay, I just signed the order terminating the PPO. And the order dismissing the show cause. So you're all set, sir.
All right, thank you.
You're welcome. Okay, Mr. Kelly, or Mr. Falley, rather, we are ready on Keller versus Rowley. I see Kim Rowley's present. And let's see, Ashley Keller is present. I will let her in.
Who does Mick represent in this one?
We'll ask him in a moment. Okay, Ms. Rowley, you can hear me?
Yes.
And Ms. Keller, you can hear me?
Yes.
All right, and I'm sorry, Mick, I forgot who it is that you represent.
Thank you, Judge. Michael Falley on behalf of the respondent, Kimberly Rowley.
Okay, so Ms. Keller, you are the petitioner here. I'm assuming by your presence today, you would still like me to issue a PPO against Ms. Rowley, correct?
Yes, sir.
All right, so I'm going to need to take some testimony from you to determine whether or not there's a valid basis for me to enter a PPO. Before I move forward with that, is there anyone else that you asked to be present as a witness today other than yourself?
My entire house can be a witness. My boyfriend Randall can be a witness. Both my kids can be a witness.
And those are all people that are present with you?
Yes.
Which, would you like me to hear from you first or hear from one of them first?
You can hear from me first.
All right, I'm gonna have to ask you to have everyone else leave the room. I don't want them to hear this.
I'm by myself and I have a headphone in.
All right, raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Put your hand down. State your full name for the record.
Ashley Jean Keller.
All right, and if I remember correctly, your relationship to Ms. Rowley, she is your children's grandmother through their deceased father. Is that correct?
Correct.
Okay, tell me why it is you think you need a PPO against Ms. Rowley.
Because after the grandparenting time, I asked Kimberly to stop. She continuously sent letters to my house weekly for me, my boyfriend, and both kids. And since she's been served with the PPO, my sister-in-law told me she had a gun on her hip when she was served with the PPO. And since she's
Ma'am,
been
that's, hold on. I don't want you to tell me what somebody else told you. That's hearsay. It's not admissible. So, you said
with the PPO, I'm still receiving letters from the kids' half siblings that haven't wrote my kids in 6 years.
Well, what, have you received letters from Ms. Rowley?
Not since she's been served the PPO.
Well, there is no PPO, ma'am. The PPO was denied.
Well, not since she's been served the packet for the PPO for this hearing.
I got you. Well, what kind of letters was she sending you?
She was sending both of the kids a letter asking how their week was, even though neither one of them was replying to her. She continuously sent letters. She was sending me and my boyfriend letters saying, I've done everything demanded. When can I see my grandchildren?
What else has she done besides sending you letters?
She's drove to my house. She's drove by my house. She's brought the siblings to my house and let them beat on my door for an hour. She's called when she wasn't supposed to have my phone number. She's ordered my kids' school pictures without my permission.
So when did she drive by your house? On what occasions?
I seen her out there. I don't remember the exact date. I was out there with my cousin working on one of my cars, and she drove by screaming my name in a blue truck.
Are the letters that she's sending you threatening in any way?
No, but she's been asked to stop. Obviously, my kids don't want to talk to her. They would have wrote her back or called like her letters requested. And my oldest daughter did write her back and say she didn't want to talk to her at this time. And obviously that didn't get through Kim's head. She continued to write her.
Is there anything else that she's said or done that you believe justifies a PPO?
She admitted to everything she did in the grandparenting time hearing. That she brought kids over, she's dropped presents off, she showed up, she's put mail in the mailbox, she's mailed letters.
When's the last time she did any of these things?
The last letter we received from Kim was just a couple days before my sister-in-law served her with that packet.
Anything else you'd like to say in support of your request?
No.
Questions for her, Mr. Felly?
Judge, I'd make a motion to dismiss the petition at this point. I think even if the court takes all of the testimony today at face value, it's not enough for a personal protection order. We'd ask the court to dismiss the petition. I would point out further, Judge, that essentially what this sounds to me like is Ms. Keller seeking a PPO against a grandmother for trying to be a grandmother. That's it. The burden of proof in these PH files, the way I understand it, statute's silent. I think it's a preponderance of the evidence. When you have a PP file with a domestic relationship, the burden of proof is reasonable grounds or reasonable cause, which I think is lower. So I would just ask the court to deny it, even if the court takes everything as true. This isn't a basis for a PPO. And quite honestly, it's too bad that Ms. Keller isn't willing to allow these children to have any type of a relationship with their deceased father's mother. Judge, if you remember, we had the grandparenting time hearing in this case, and I think that's a good thing because you had an opportunity to hear both of these parties testify previously. And in fact, at the end of that hearing, you encouraged the parties to try to resolve their differences and move forward and work together. And after that happened, my client sent these letters, which I can read into the record if you want them, Judge, to Ms. Keller saying that she apologized for any of the issues she had caused in the past, and she'd love to be able to communicate or see her grandchildren. That's basically it. And now Ms. Keller, hasn't indicated at all that she's scared or threatened by Ms. Rowley, and I would just ask the court to dismiss the petition.
I'm going to grant the request. I'm going to dismiss the petition. I will tell you, Ms. Rowley, don't send any more letters to Ms. Keller. I won't stop you from trying to write to your grandchildren, whether or not those letters get through. I appreciate the frustration that you want to be part of your son's children's lives. I get that. Unfortunately, there isn't a legal basis for me to do that. I would hope maybe in time some of the pain would erode. I understand why you would have written letters to Ms. Keller after I made encouragement to the parties to try to make peace for the sake of the children. But I'm just going to tell you, please don't send her any more letters. Don't drive by her house. Don't take kids over to knock on the door. Just stop doing those things. If you want to send cards or letters to the children, I wouldn't have stopped you from doing that, even if I'd granted a PPO against letters to Ms. Keller. But as long as the letters are not threatening or harassing, I wouldn't stop you from doing that. Whether or not Ms. Keller's going to give those letters to the children, I don't have any control over. But I leave that to you. But please, you need to let Ms. Keller have her space. Thank you.
Thank you, Your Honor.
Is there an order in that one, Your
No.
Honor?
Are we free to leave, Judge?
You are. Have a good day.
Thank you, Judge.
When you came back out, I did not go back on the record on Johnson and Lester. Can you just say what happened?